came into effect, there was a stay which was granted from 30th March 2010. Your Lordship, the counter evidence Annexure A and Annexure B, which is at page number 17 and 18, would make it clear. Your Lordship, there was a stay from 30/3/2010 that there will be no appointment further. And thereafter, Your Lordship, RTE Act came up, and by letter dated 1/7/2010, there was a change in the eligibility criteria which made trained education TET mandatory.
So, which is the letter the petitioners are challenging?
Your Lordship, the petitioner is challenging this letter 1/7/2010, which is at Annexure A.
Annexure 6 to their counter,
Yes,
to the writ
Annexure 6
application.
to the writ application.
Annexure 6.
Lordship, if I may state, Your Lordship, this matter has already been settled by a coordinate bench, WPS number 7152 of 2011.
7152 of 2011.
Your Lordship, in this
Not
case
the
also
counsel,
it is
not the counsel for the state. The petitioner is challenging a letter issued by the district project director. A letter dated 1/7/2010 within bracket Annexure 6 issued by so and so.
State project director, minutes.
State project director, whereby a direction has been given not to appoint any primary school teachers who is not having the requisite qualification, that is teachers training eligibility. First up, next paragraph. Counsel for the petitioner submits that an advertisement was published pursuant to which a recommendation was made on 17/2/2010, recommending the name of the petitioners for appointments as a parateacher. As
yes, sir.
a parateacher, first up. He admits, the counsel for the petitioner admits that at that point of time, the petitioners were not trained. That is, they did not possess the qualification of TET, Teachers Eligibility Test, first up. It is his submission that at the relevant point of time, it was also not a necessary qualification, first up. He submits that since the recommendation was already made, the state government should have proceeded with the same recommendation, and could not have issued the impugned letter dated 1/7/2010. He praised that the recommendation be given effect to and the petitioners be appointed. Next paragraph. Counsel for the state and the state project
JEPC, Jharkhand Education Project Council.
Education Project Council submits that an advertisement was admittedly issued and the petitioner or petitioners
Petitioners.
petitioners applied and they were recommended for appointment. They also admit at that relevant point of time when the advertisement was issued, teachers eligibility test was not a criteria, was not a criteria, full stop, for appointment, criteria for appointment. They submit that before issuing any appointment letter, the Right to Education Act
With effect from 1st April 2010 minutes.
Came to effect from 1st April 2010. He submits that by virtue of the aforesaid act, no person who is trained could have been appointed as a teacher. Thus, the impugned letter was issued. Full stop. The respondent submits that admittedly The petitioner was name of the petitioner was mainly recommended, and recommendation the said recommendation uh, doesn't create any right in favor of the petitioners to get appointed. He submits that appointed. Full stop. Next part. After hearing the counsel for the parties, I find that it is an admitted fact that on the date of recommendation, the petitioners were not trained. Full stop. It is also an admitted fact that the petitioners were only recommended and they were not appointed. Full stop. It is also admitted that from 1/4 2010, the Right to Education Act came to effect, which mandates that a teacher must be trained to be appointed. A person must be trained as a teacher to be appointed. Full stop. Considering the aforesaid admitted facts, since the petitioner was not trained, the recommendation was not given effect to. Full stop. A mere recommendation creates no right in favor of any recommendation for appointment creates no rights in favor of the candidate. Full stop. Thus, admittedly, when the petitioner was not a trained teacher, was not a trained candidate, in view of the Right to Education Act, the petitioner could not have been appointed. First up, thus I find no illegality in the impugned letter. First up, this application is thus dismissed.
Obliged, Your Lordship.
Obliged, sir.
Serial number 15, WPS 7214 of 2011, Mr. S.K. Sharma, Mr. Lukesh Kumar, Mr. Rishi Pallava.
So this case was I was mentioning in the morning also. I'm praying for not today only in this case.
Let us see what is it. What is your prayer?
I don't have file, I could not assist.
Sudhir Kumar Sinha, Rishi Pallav, Lukesh Kumar. This is also para teachers. Yes.
So I will pray for not today only. Otherwise on Monday, let's say if possible.
Let's say para teacher matter have not been served, plus only I'll request if so, plus
You have not served.
whether they have made a party or not, plus the JPC or plus the state
You have been added.
added, plus then they have not served the copy, plus my name is not appearing. Plus.
You serve a copy.
What's it? What's that?
Lukesh Kumar will serve a copy of this writ application, the pleadings of this case to Mr. Krishna Murari, who appears on behalf of Jharkhand Education Project. Full stop. This case after 2 weeks?
As Lord.
2 weeks.
Madam, for the state in this matter.
Serial number 16, WPS 7311 of 11, Mr. Prakash Singh, Mr. Kundan Kumar Ambassador, Mr. Mahesh Tiwari, Mr. Naveen Kumar.
In this case, Madam, I am appearing for the petitioner, my lord. The second round of litigation, my lord, between filed by the petitioner, my lord. Petitioners, my lord. All the 6 petitioners, my lord. In the first round of litigation, my lord, the matter was remanded to Secretary Cabinet Coordination, my lord. He has passed the impugned order, my lord. Impugned order is at page 72. Matter relates to the regulation of the services of the petitioner, my lord, who are working for more than 20 years, my lord, now. The impugned order is of year 2011, my lord. And now still they are working, Lord. We are in 2022, my lord. But their claim has been rejected on the ground, my lord, that they are not working continuously for 10 years, my lord, and they are not working for this sanctioned post, my lord. I have also made some private respondents in this case, my lord, who have been appointed by the state government in the year 2010, my lord, without, although they all were daily wage workers, my lord, and others, my lord. Recently, my lord, judgment of in the case of my lord Narendra Kumar Tiwari versus State of Jharkhand, Honorable Supreme Court has made certain guidelines, my lord, for considering afresh the matter of regulation of the state for the state of Jharkhand, my lord. If your lordship will permit me, I may send the judgment, my lord.
No, just tell me where is the impugned order? Let us go through the
The impugned order is not page 78 and extra 24, my lord.
State they are working.
Still they are working, my lord. We are in 22, my lord. Still they are working, my lord. All 6, my lord. Lord, earlier, my lord, first they have regularized service of 20, my lord, persons, my lord, which I have made all of them party respondent, my lord. Some of them are working in the state of Bihar, my lord, on daily wages, my lord. They have been transferred, my lord. Unheard of, my lord, daily wage persons have been transferred. It has come in the counter affidavit, my lord. Para 34, my lord. Your lordship will permit me, my lord, counter affidavit filed by the state.
Transferred.
They have taken the plea, my lord. My lord, para 34, my lord, of the counter affidavit.
Para 34 of the counter affidavit.
Lord, very alien to my lord. The para 34, my lord.
Just a minute.
Page 33, my lord.
Para 34 of the counter affidavit.
Counter affidavit Lalit Kishore Srivastava, my lord. Under Secretary Cabinet Secretariat.
Right. Para
34, page 33, my lord.
page 30.
3, my lord. May I read, my lord, if your lordship got it?
Yes.
That with regard to the statement made in paragraph 30 of the written petition, it is stated that, and mentioned in the above paragraph, the services of daily wages were transferred to the newly created state of Jharkhand following due process and rights, because they fulfill the conditions prescribed in the aforementioned court order, my lord. I have made them party, my lord, all 20, my lord. All are daily wage earners, my lord, in the state. Some are state in Bihar, some are deputy commissioner, collectorate, my lord, in the district, my lord, and we are.
So they have been regularized.
They have been regularized, my lord. And in our case, my lord, they say this document is under suspicion. This is not verified, my lord. We are still working, my lord. Some are working from last more than 20 years, my lord.
Yes, state.
Lordship, as per the counter affidavit, Lordship, it is stated that none of them fit the criteria of 10 years of continuous service against sanctioned post, Lordship. Therefore, their services were not recognized, regularized, Lordship.
Still now they are working.
Lordship, I'll have to seek instruction on that point, Your Lordship.
Don't remove them. Don't try to remove them if they are still working.
Lordship.
Seek instruction and tell me next week.
Lordship, 2 weeks time may be given, Lordship, because I have weddings. My wedding is there, Lordship, next week. So,
This is after 2 weeks.
Lordship.
The State Council will inform this court as to whether the petitioners are still working or not.
Lordship.
Don't try to remove them.
Lord.
If this status quo. If you try to remove or if you pass any order, I will see that all your records are seized.
Lordship.
Obliged.
Thank you, Lordship.
Serial number 17, WPL 7320 of 11, Mr. Arvind Kumar Chaudhary for the petitioner.
Lordship, in this case, I am appearing on behalf of the petitioner, Lordship. On the instruction of Mr.
Arvind Kumar Chaudhary, Lordship, I'm praying for 1 week time, Lordship, in this case, Lordship, because the matter is old, Lordship, and the client is not in contact, Lordship. Therefore, Lordship, one adjournment may be given, Lordship, to seek the instruction.
C2.
Yes, my Lordship.
What is the existing rights? How is this application under section 33C2 mentionable?
Lordship, only one adjournment may be given, Lordship. I will assist your Lordship on this point, Lordship, and we'll take the.
How is this 33C2 mentionable? Tell me. What is 33C2?
Lordship, in paragraph number 4 of the writ petition, Lordship, earlier the application has been filed under section 33C2, but later on it was amended, Lordship.
It was amended.
Yes, your Lordship. Later on, amended by wide order dated 19/11/2003, Lordship. It is stated in paragraph number 4 of the application, Lordship.
So now I explained 10 years delay. The court says that you have not explained 10 years delay.
Lordship, and Lordship, only one adjournment, Lordship. I will seek the instruction, Lordship. What is the current position of the petition? Also, only one adjournment.
Who is for? Who is for the Patna Industrial Area Development Authority?
Your Lordship, I am for state in this case, Your Lordship.
Who is the Patna Industrial Area Development Authority? You serve a copy of this petition on Mr. S.P. Rai.
Yes, Your Lordship. I will serve the same, Lordship.
Will you take down?
I am appearing on behalf of the state of Bihar, Lordship, in this matter.
Oh, you are appearing now.
We have not been implicated as one of the parties in the matter, although I am ready
no.
to proceed with
The counsel for the petitioner will serve 2 copies of this petition upon Mr. Purnendu Sharan, who appears on behalf of the state of Bihar. Full stop. Mr. Sharan, he is claiming some wages. He states that he was kept on daily wages, but no payment for a particular period has not been made. Now, the tribunal has dismissed his claim as the same is time barred. He has approached after 10 years. You just see what your records reflects, whether the records are there or not also.
We will verify, Lords.
It is Patna Industrial Area Development Authority. And if as per you, the petitioner is entitled to get 10 rupees, 5 rupees, 100 rupees, any amount, as a model employer, please give it. Don't take this ground of limitation. If he is entitled, as per you.
I'm saying lordship, a copy of read petition to be served upon us, lordship, for
Yes,
doing.
Today itself, I will serve. Today itself, lordship.
Okay, thank you.
Oblige.
Oblige, oblige.